I wanted to talk to you a little bit about strategies regarding sex crimes. I've been handling sex crime defense now for 26 years in Los Angeles County. I've actually handled cases all over the nation, but specifically in LA, there's a lot of sex-related offenses, and I thought it might be a good idea to break things down so you kind of get a feel for how they're handled, what some strategies are, and of course, you're going to have to sit down and meet with somebody like me so we can see how these strategies apply to you. First, when you're defending sex crime cases, we got to talk about pre-filing and we've got to talk about pretext phone calls. So basically what the police have is a victim comes into them, tells them a story about what happened. A lot of times the story's all over the place. Sometimes they can't remember. Sometimes they used alcohol, drugs, whatever the case may be. So in order to corroborate that story, the police are going to do a pretext phone call. They're going to have the alleged victim call you, and the police are going to tape record the conversation. And then they're going to give that alleged victim questions to ask you to try and elicit some sort of a response for you that they can use to prosecute you. Because they know it's a problem when somebody comes in, it's just their word against somebody else's word. Maybe there might be some motives to lie. And of course, the other party is going to have their own version of events. So to get this corroborative pretext phone call is crucial for the police. So obviously that's something we will talk about at the pre-filing stage when you come in and you talk about me if you suspect you might be under investigation for a sex crime. Also, we're going to talk about you talking to the police. It's never a good idea in my experience. Again, I've been doing this for 26 years. I've worked for the DA's office, I've worked for a Superior Court judge, and I've been a criminal defense attorney defending sex crimes since 1994. So I have a lot of experience handling thousands of cases in the 38 courts in Los Angeles County. So I tell my clients never to talk to the police. When you hire me, especially during the investigative stage, pre-filing, I'm going to be the one that deals with the police if they come knocking. I'm going to act as your buffer, so never talk to the police. Hire an attorney like me and let me be the one that guides you through the process. Last thing in this pre-filing, I think having an attorney is a huge advantage because that way you don't have to talk to the police. What if you talk to the police and they claim that you said something that you didn't really say? How are you going to unring that bell? You can't, especially if they didn't tape record it. So if you just don't talk to them, they can't claim you said anything you didn't say. They can't twist your words around. Maybe you said something, but they took it out of context. Bottom line is let your attorney do the talking, especially in sex crime cases at the investigative stage, at the pre-filing stage. But during any part of the case, let your criminal defense attorney handle the case for you, help you make the right decisions. The next area is whether or not you're going to defend the case or whether or not you're going to work out a deal. And that's the first decision. Are you going to fight it or are you going to mitigate it? Once you make that decision, then the pieces fall into place. If you decide to fight the case, the great thing for me is I don't even really have to talk to the prosecutor about anything related to trying to work things out, character letters, any of the mitigating stuff that I might normally do, I'm not going to do because we're aimed at trying to win the case. But if you're like most people, and it's probably better than 95% of the cases, the prosecutors didn't have you arrested, didn't charge you with a crime if they didn't think you were doing something wrong. So you're probably going to have to negotiate or try and mitigate things. So what we'll do is we'll put together a mitigation practice and we're going to look at everything. We're going to look at character letters. We're going to look at what happened. We're going to look at your version of events. Maybe the alleged victim's version of events is not completely accurate, and we're going to be able to show the prosecutors that there's some problems with their case. Sometimes that can help us resolve the case, get a lesser charge, whatever the case may be. In talking to the prosecutor and looking at the evidence, which is kind of what we're doing when we're deciding whether to defend the case or whether to mitigate the case, we're going to lay out all the evidence. I'm going to talk to the prosecutor on your behalf. I want to hear what they have to say. That's one of the best conversations I have. One of the most helpful conversations I have is to say to the prosecutor, look, my client really doesn't understand why you guys have charged him. He doesn't understand what he did wrong. Can you please explain it to me? And now I'm going to get some great information. There's nothing wrong with that. We gather the information, I come back to you, we talk about it, and we decide whether they've got the right, accurate information that makes sense, or whether they've been given some misinformation that needs to be clarified. The next thing we're going to look at is sex registration. And I'm going to tell you right now, when it comes to sex registration, obviously nobody wants to have to register as a sex offender. But what I'll tell you is the registration depends on what crime you plead to. And when it comes to sex crimes, there's a huge list of crimes that require sex registration. There's a very small list of crimes that don't require you to register as a sex offender, but relate to sex registration. For example, let's say that somebody's accused of touching somebody in a sexual manner, either on their breasts, their butts, their vagina, and they're charged with sexual battery. That is a crime, even though it's a misdemeanor and doesn't sound that serious, that requires you to register as a sex offender. But the crime of simple battery, Penal Code Section 242, does not require you to register as a sex offender. So if we're trying to avoid sex registration, first we're going to have to find a charge that fits what you purportedly did, that you don't have to register as a sex offender if you plead to that charge. Obviously, also, we're going to have to make the determination, as we discussed, whether or not you're going to fight the case or whether or not you're going to mitigate and try to work something out with the prosecutors. The next thing that I think you really need to consider is whether or not you're going to go to jail or you're going to go to prison based on what you did. This has to be talked about. Nobody wants to go to jail. Nobody wants to go to prison. Your safety is in danger. So we've got to talk about, we have to talk about whether it's really realistic that you're going to go into custody. And if you are going to go into custody, for how long and how can we protect you? If we just bury our heads and don't talk about that issue, then we're doing you a disservice. So if we're trying to get no jail time, if no jail time or no prison time is realistic in your scenario, we've got to think of ways to convince the prosecutor and the judge that if they give you that break, if they don't put you in jail, if they don't put you in prison, are you going to do this again? Are you going to be a recidivist? And that's why a lot of times in these type of cases, we're going to get a report from a psychiatrist who has handled sex-related offenses, and they're going to give a recommendation based on all the information, whether they think you might do this again, whether they think there's something other than custody time that could help you and cause you not to be involved in this circumstance again. Finally, I put basically experience is crucial. When it comes to sex crimes, I can't tell you how many attorneys I've seen mess a sex crime up, especially defense attorneys or the attorneys who think they can handle sex crimes. They say or do something that completely messes the case up and puts their client in a bad position. It doesn't put them in a bad position, it puts their client in a bad position. And that's why it's so crucial to get somebody who has experience. I'll give you an example. I had a case that I took over for somebody else, and in that case, it was a loser case for the defense. In other words, it was one that we needed to mitigate. It wasn't one that we needed to fight. But that attorney didn't do that. They weren't sophisticated enough to figure out how to go to the superior, the boss, and get a better resolution than what was offered by the prosecutor who was handling the case. So they did the preliminary hearing in the case, forcing the alleged victim to testify, and the prosecutors hate that. They're supposed to make the best resolutions before putting an alleged victim through being cross-examined by a defense attorney, embarrassing themselves, putting them on the witness stand, because that is part of the victimization from the prosecutor's standpoint. So obviously, if you don't have a good case, why would you put the victim on the stand? But this attorney did that. So I had to unring that bell and undo that problem. Now, there are some cases where you do want to put the alleged victim on the stand, either because your client is innocent or because pointing out some problems in their testimony, in their credibility, in their story is going to help your client. But you've got to have the attorney who has the wisdom, the knowledge, the experience, and the know-how to know when to put an alleged victim on the stand and when not to. Well, you've come to the right place. I've been doing this a long time. I know how to handle these cases. If you need my help, pick up the phone now and we can discuss your case in the privacy of my office, over the phone, whatever you deem appropriate. And we can begin to put you back in the position of taking control of your life and your case.